Planning end-of-life care is a complex matter. Although it is very hard to talk about the final phase of life, it can be a great gift to your family and loved ones to prepare them in advance for the ever so often difficult and distressing decisions that must be made. It may be hard to talk about, but it is important to make plans for the end of your life while you are of clear mind and sound body. During an emergency or at the end of life, you and your family may be faced with questions about your medical treatment and might not be able to answer them. You may assume your loved ones know what you want, but that's not always true. In one study, about 1 out of 3 end-of-life decisions for their loved one was guessed nearly incorrectly by families. Research shows that you are more likely to get the care you want if you have conversations about your future medical treatment and put a plan in place. It may also help your loved ones grieve more easily and feel less burden, guilt, and depression. Here at Parker, we are patient-focused and are committed to ensure our patient rights are upheld and their choices are secured. In a nursing home setting, our residents are frail, older adults with a higher probability that they may develop cognitive impairment or loss of decision-making capacity towards the end of life. So at Parker, we support our residents and patients in understanding and sharing their personal values, life goals, and preferences regarding future medical treatment and care. While you are here at Parker, if you have not already done so, we strongly encourage you to speak with your doctor or social worker and start the discussion in advanced care planning. If you already have an advance directive in place, it is important to re-examine your goals and wishes. In the event that you would like to make changes, please reach out to your doctor or social worker to discuss further. This video will discuss advanced care planning and steps you can take to ensure your personal choices and decisions are acknowledged and granted. What is advanced care planning? Advanced care planning affords you the opportunity to speak with your healthcare provider to plan for future medical care in case you become seriously ill or unable to communicate your wishes or unable to make your own decisions. It may include preparation of one or more straightforward legal forms, which can help to ensure that your healthcare decisions are followed and decisions are made by people you trust. Importantly, advanced care planning begins by thinking through possible future healthcare scenarios and having meaningful conversations with family and friends about your wishes. What are advance directives? Advance directives are legal documents by which you may make provisions for future healthcare decisions in the event that you are unable to make such decisions for yourself. These documents provide instructions for medical care and only go into effect if you cannot communicate your own wishes. There are 3 types of advance directives for healthcare in New York State. Healthcare proxy form. A healthcare proxy form lets you appoint a healthcare agent, such as someone you trust, to make healthcare decisions for you if you are unable to make decisions for yourself. In order for the healthcare proxy to become effective, 2 doctors must decide that you are not able to make your own decisions. You can complete a healthcare proxy form if you are 18 years of age or older. A healthcare proxy form, established under New York law, allows you to appoint someone you trust to make healthcare decisions on your behalf if you are no longer able to do so. You can tell your wishes to your agent orally or in writing. New York law requires hospitals and nursing homes to provide you with the healthcare proxy form and information about creating a proxy. Living will. A living will is a legal document that allows you to leave written instructions that explain your healthcare wishes, especially about end-of-life care. This document becomes effective when you are unable to make your own decisions and your doctor confirms that you have an incurable condition. You cannot use a living will to name a healthcare agent. You must use a healthcare proxy form. A living will tells doctors how you want to be treated if you cannot make your own decisions about emergency treatment. In a living will, you can say which common medical treatments or care you would want and which ones you would want to avoid, such as dialysis, breathing machines, resuscitation, tube feeding, and organ or tissue donation after you die. Do not resuscitate order. CPR, or cardiopulmonary resuscitation, is an emergency procedure to restart the work of your heart and lungs by compressing the chest overlying the heart and forcing air into the lungs. Additional life-saving procedures include mechanical ventilation or respirator and intravenous medications to regulate blood pressure and heart rhythms. Do not resuscitate order, or DNR, is a medical order written by a doctor. It instructs healthcare providers not to perform cardiopulmonary resuscitation, CPR, or other life-saving emergency procedures if your heartbeat or breathing stops. This means that doctors, nurses, or emergency personnel, like paramedics, will not initiate emergency procedures such as mouth-to-mouth resuscitation, external chest compression, electric shock, insertion of tube to open your airway, or injection of medication into your heart or open chest. You can make your hospital DNR wishes known in your healthcare proxy, living will, or a state-approved medical orders for life-sustaining treatment form. This is also known as a MOST form. A DNR is arranged with your doctor or healthcare provider before an emergency occurs. A DNR becomes part of your medical chart to inform medical staff in a hospital or nursing facility that you do not want CPR or other life support measures to be attempted if your heartbeat and breathing stop. Sometimes this document is referred to as a do not attempt resuscitation order or an allowed natural death, A&D order. Even though a living will might state that CPR is not wanted, it is helpful to have a DNR order as part of your medical file if you go to a hospital. Posting a DNR next to your hospital bed might avoid confusion in an emergency. Without a DNR order, medical staff will attempt every effort to restore your breathing and the normal rhythm of your heart. In New York, any adult 18 years or older can get a hospital or non-hospital DNR order. A hospital DNR order is issued if you are in a healthcare facility, such as a hospital, nursing home, or a mental hygiene facility licensed by New York State. Emergency personnel, EMS, must honor your hospital DNR order during transfer. But if you are outside any of these facilities, at home, for example, you may want to get a non-hospital DNR order. Your non-hospital DNR order must be recorded on a state-specific form, a DOH 3474, and signed by a doctor. Other advanced care planning forms and orders. You might want to prepare documents to express your wishes about a single medical issue or something else not already covered in your advanced directives, such as an emergency. For these types of situations, you can talk with the doctor about establishing the following orders. Do not intubate, DNI order. A similar document, a DNI informs medical staff in a hospital or nursing facility that you do not want to be on a ventilator. Do not hospitalize, DNH order. A DNH indicates to long-term care providers, such as nursing home staff, that you prefer not to be sent to a hospital for treatment at the end of life. Out-of-hospital DNR order. An out-of-hospital DNR alerts emergency medical personnel to your wishes regarding measures to restore your heartbeat or breathing if you are not in a hospital. Power of attorney for health care. A durable power of attorney for health care is a legal document that names your healthcare proxy, a person who can make healthcare decisions for you if you are unable to communicate these yourself. Your proxy, also known as a representative, surrogate, or agent, should be familiar with your values and wishes. A proxy can be chosen in addition to or instead of a living will. Having a healthcare proxy helps you plan for situations that cannot be foreseen, such as a serious car accident or stroke. Power of attorney allows you, the principal, to appoint an agent to act for you immediately upon its execution or the occurrence of some future event identified by you and lasts until cancellation by you or upon your death. This power continues when you are mentally or physically incapacitated. Physician orders for life-sustaining treatment, POLST, and medical orders for life-sustaining treatment, MOLST forms. These forms provide guidance about your medical care that healthcare professionals can act on immediately in an emergency. They serve as a medical order in addition to your advance directive. MOLST form allows doctors to record your preferences regarding cardiopulmonary resuscitation, CPR, mechanical intervention, and other life-sustaining treatments on one form as a physician order. It must be completed by a healthcare professional and signed by a New York State licensed physician to be valid. Typically, you create a pulse or MOLST when you are near the end of life or critically ill and understand the specific decisions that might need to be made on your behalf. These forms may also be called portable medical orders or physician orders for scope of treatment for a post. A valid MOLST form serves as a physician order form and can be transferred with you from one healthcare setting to another. Remember, while the MOLST form may help centralize your end-of-life wishes and summarize your advance directives, it is not intended to replace your healthcare proxy form and/or living will. MOLST translates your current medical treatment preferences into physician orders, whereas your healthcare proxy and/or living will guides future medical care. You may also want to document your wishes about organ and tissue donation and brain donation. As well, learning about care options such as palliative care and hospice care can help you plan ahead. Palliative care. Palliative care is a multidisciplinary approach to specialized medical care for people with life-limiting illnesses, focusing on providing people with relief from the symptoms, pain, physical stress, and mental stress of the terminal diagnosis. Surrogate. A person close to you, as defined by New York State law, who can make decisions on your behalf if you have lost the capacity to make decisions about your medical treatment and have not appointed a healthcare agent. Who needs an advanced care plan? Advanced care planning is not just for people who are very old or ill. At any age, a medical crisis could leave you unable to communicate your own healthcare decisions. Planning now for your future healthcare can help ensure that you get the medical care you want and that someone you trust will be there to make decisions for you. What happens if you do not have an advance directive? If you do not have an advance directive and you are unable to make decisions on your own, the state laws where you live will determine who may make medical decisions on your behalf. This is typically your spouse, your parents if they are available, or your children if they are adults. If you are unmarried and have not named your partner as your proxy, it's possible they could be excluded from decision making. If you have no family members, some states allow a close friend who is familiar with your values to help, or they may assign a physician to present your best interest. Will an advance directive guarantee your wishes are followed? An advance directive is legally recognized, but not legally binding. This means that your healthcare provider and proxy will do their best to respect your advance directives, but there may be circumstances in which they cannot follow your wishes exactly. For example, you may be in a complex medical situation where it is unclear what you would want. This is another key reason why having conversations about your preferences is so important. Talking with your loved ones ahead of time may help them better navigate unanticipated issues. There is the possibility that a healthcare provider refuses to follow your advance directives. This might happen if the decision goes against the healthcare provider's conscience, the healthcare institution's policy, or accepted healthcare standards. In these situations, the healthcare provider must inform your healthcare proxy immediately and consider transferring your care to another provider. Who should have copies of my advance directive documents? Copies of your documents should be with your doctor, your hospital, or long-term care facility. the person designated as your agent, and members of your family. The original document should be kept safely with other important legal paperwork, such as birth certificates. How will my healthcare provider know I have an advance directive? You should tell your doctor, nurse, and other healthcare provider that you have an advance directive and provide them with a copy of your medical record. Anytime you're admitted to a hospital, you will be asked if you have an advance directive, so it is important to bring a copy of the document along with you. Are old advance directive documents still valid? Yes, an advance directive does not need to be renewed. However, if you would like to change something in your advance directive, then you're required to complete a new document. It is important to re-examine your healthcare wishes from time to time. Canceling your advance directives. An advance directive remains in effect indefinitely unless you cancel it, include an expiration date, or describe the circumstances that trigger expiration. You can change or cancel your advance directives at any time. It is important to review the forms you have signed from time to time to make sure they express your current healthcare wishes. You can cancel your healthcare proxy by notifying, orally or in writing, your healthcare agent, doctor, or others who have copies. You can cancel the appointment of the agent on your healthcare proxy at any time and appoint a different agent in a new proxy. If your spouse is your appointed healthcare agent, your healthcare proxy is automatically canceled upon divorce. You can cancel your living will at any time by destroying the document. You are not required to notify anyone before canceling it, but it would be wise to inform those aware of its existence that you have canceled it. Canceling your DNR. In general, you or your healthcare agent can cancel a DNR order at any time in any way that makes your wish known. This can include the following: your oral or written statement to a doctor or nurse, your act that shows an intention to cancel your consent, such as destroying the document that references the DNR order, removing any bracelet or medallion which indicates your DNR status, orally telling emergency responders not to pay attention to the order. How can you get started with advanced care planning? To get started with advanced care planning, consider the following steps. Reflect on your values and wishes. This can help you think through what matters most at the end of life and guide your decisions about future care and medical treatment. Talk with your doctor about advanced directives. Advanced care planning is covered by Medicare as part of your annual wellness visit. If you have private health insurance, check with your insurance provider. Talking to a healthcare provider can help you learn about your current health and the kinds of decisions that are likely to come up. For example, you might ask about the decisions you may face if your high blood pressure leads to a stroke. Choose someone you trust to make medical decisions for you. Whether it's a family member, a loved one, or your lawyer, it's important to choose someone you trust as your healthcare proxy. Once you've decided, discuss your values and preferences with them. If you're not ready to discuss specific treatments or care decisions yet, try talking about your general preferences. You can also try other ways to share your wishes, such as writing a letter or watching a video on the topic together. Complete your advance directive forms. To make your care and treatment decisions official, you can complete a living will. Similarly, once you decide on your healthcare proxy, you can make it official by completing a durable power of attorney for healthcare. Share your forms with healthcare proxy, doctors, and loved ones. After you've completed your advance directives, make copies and store them in a safe place. Give copies to your healthcare proxy, healthcare providers, and lawyer. Some states have registries that can store your advance directive for quick access by healthcare providers and your proxy. Keep the conversation going. Continue to talk about your wishes and update your forms at least once each year or after major life changes. If you update your forms, File and keep your previous versions. Note the date the older copy was replaced by a new one. If you use a registry, make sure the latest version is on record. Everyone approaches the process differently. Remember to be flexible and take it one step at a time. Start small. For example, try simply talking with your loved ones about what you appreciate and enjoy most about life. Your values, treatment preferences, and even the people you involve in your plan may change over time. The most important part is to start the conversation. How is incapacity determined? Generally, an adult patient is presumed to have the capacity to make medical decisions. This means that you will make your own healthcare decisions until your physician determines to a reasonable degree of medical certainty that you are incapable of making medical decisions. The initial determination must be made by an attending physician, and it must include information about the cause and extent of the patient's incapacity and the likelihood that the patient will regain decision-making capacity. Under certain circumstances, New York requires a concurring determination to declare a patient incapable of making healthcare decisions. A healthcare provider or social worker who is affiliated with the hospital or nursing facility may make the concurring determination in place of a physician. The number of determinations will depend on where you are as a patient and what care is required. In cases of mental illness or disability, while any condition may lead to incapacity, New York sets out specific requirements for determining incapacity caused by mental illness or developmental disability. Those initial determinations must be made by a physician who is qualified to work with those populations and cannot be made by an ordinary attending physician. This ensures that people with mental disabilities are not unnecessarily stripped of their rights to make medical decisions for themselves. If you have a mental illness or disability, you will not be automatically declared incapable of making your own medical decisions. For more information, please visit the links provided. Thank you.